The gate was brand new, black iron, laser-cut letters arching across the top, Saddleback Ridge Estates, security keypad, brick pillars with gas lanterns burning at 10 in the morning, manicured hedges so perfectly trimmed they looked like they'd been painted on. I stood at the entrance of my family's 380-acre ranch, land my grandfather quarried limestone for with his bare hands, and a man in a polo shirt stepped out of a guard booth and asked me for my resident pass. I said, "I don't need a resident pass, I have a deed." He didn't know what to do with that. Neither did the 200 families living behind that gate, families who had been paying Claudette Pryor thousands of dollars every single month for land that was never, not for one single day, hers to sell. What Claudette never counted on was simple. Deeds don't expire, and neither does a ransom. My name is Wyatt Ransom. I just got home from 14 years of serving this country, and I came back to claim what my grandfather left me. Before we go any further, drop a comment right now. Where in the world are you watching from, and what time is it there? Let's see how far this story travels. Stay with me, because what happened next took down an $18 million fraud empire, and every single piece of it is documented. My name is Wyatt Ransom, third-generation Texas ranching family. I spent 14 years in the United States Army, 2 tours Iraq, 1 Afghanistan. When I came home, I didn't go back to Kerrville. My father and I had a falling out years before. I settled in Fort Worth, built a quiet life, and told myself the ranch was his problem. I told myself that for 14 years. 6 months ago, a certified letter arrived from a probate attorney in Kerrville. My father had passed away. Alone, the way stubborn men do. Attached was a copy of the deed. 380 acres, Kerr County, Texas, recorded 1961. Owner of record, the Ransom Family Trust. No liens, no sales, no transfers. The land was still ours, every single acre. I booked a flight that same night expecting an empty, overgrown property and a stack of paperwork. Instead, I found a fully built, gated community. 200 homes, paved streets, a clubhouse, a pool, all of it sitting on land that still had my family's name on the deed. And not one person behind that gate knew. That's when I started digging, and what I found was worse than I ever imagined. Let me take you back to where this all started. Not with Claudette Pryor, not with the fraud, not with the gate and the guard and the polo shirt. Let me take you back to 1961, to a man named Holt Ransom, my grandfather. Holt was born in Comfort, Texas in 1931, son of a feed store owner, grandson of a cattle drover who came up from San Antonio after the war. The Ransoms were never rich. They were never connected. What they were was stubborn, the specific kind of stubborn that looks at a piece of raw hill country land covered in cedar and limestone rock and sees something worth building instead of something worth avoiding. In the spring of 1961, Holt Ransom paid $11,000 for 380 acres in Kerr County. Cash. Every dollar saved over 12 years of working oil field jobs in West Texas and cattle work closer to home. He didn't use a realtor. He didn't use an attorney. He walked into the county recorder's office in Kerrville with a cashier's check and a hand-drawn survey, and he recorded that deed himself. Then he went home and started building. The ranch house took him 2 years. He quarried the limestone from the western ridge of the property himself, chiseled it out in the early mornings before the Texas heat made the work unbearable, loaded it onto a flatbed by hand, and laid every block himself. Cedar beams for the roof, stone floors, a covered porch that faced east so you could drink your coffee watching the sun come up over the hill country without squinting. When it was finished, Holt Ransom moved his wife Ruth and their 2 boys into that house and started running cattle. Nothing enormous, never more than 80 head at a time, but steady, consistent, enough to make the land productive and enough to make the payment of $11,000 look like the smartest decision a man from Comfort, Texas ever made. He also planted a peach orchard on the South 40, 23 trees. He tended those trees every spring for 30 years. I used to eat those peaches as a kid, straight off the branch, standing in the dirt in bare feet, juice running down my arm. My grandfather would watch from the fence and not say a word, just nod, like the whole point of planting those trees 30 years earlier was specifically that moment. That's the kind of man Holt Ransom was. He died in 1993, left the ranch to my father, Garrett Ransom, his eldest son. Now, my father was a different animal entirely. Garrett Ransom loved this land the way some people love a photograph of a place they used to live, from a distance, with sentiment, but without any real intention of going back. He wasn't a rancher, he was an accountant. He worked for a firm in San Antonio for 30 years, drove a clean truck, wore pressed shirts, and came out to the property maybe 4 or 5 times a year. He kept Cutter Briggs on as ranch foreman. Cutter had worked for my grandfather since 1979 and knew every inch of the property better than any deed could describe. Cutter kept the fences up, managed a small hay operation, and essentially held the ranch together on his own, while my father paid the property taxes from San Antonio and called it stewardship. The cattle were gone by 1998. The peach orchard went untended, and eventually half the trees died. The ranch house sat mostly empty except for when my father came out for deer season. But he never sold it, I'll give him that. Whatever else I can say about Garrett Ransom, he never once considered selling that land. It was the one thing he held on to, the way his own father had held on to it. Not because he used it, but because he understood, somewhere underneath the accountant's practicality, that some things you don't sell. That brings us to 2010. But before I get there, I need to tell you about 2007. Because what happened between me and my father that year is the reason I wasn't there to stop what came next. I came home from my second Iraq deployment in the fall of 2007 with a plan. I was going to revive the ranch, run it the way my grandfather had run it, cattle operation, proper fencing, get the hayfields back into rotation. I'd spent 14 months in the desert thinking about those limestone walls and that cedar beam roof, and I came home ready to build something again. My father had other ideas. He'd been in conversations with a developer, someone he'd met through a landowners network in Fredericksburg, about leasing a portion of the eastern acreage. He said the numbers made sense, said the land was sitting there doing nothing, and this was a way to finally make it work. I told him the land was working fine. I told him Cutter had the hay operation running and the fences were sound, and all it needed was someone willing to put cattle back on it. He told me I'd been gone for 14 years and didn't understand the costs involved in maintaining 380 acres of hill country property. I told him I understood it fine, that our grandfather had maintained it on an oil field worker's wages. We went back and forth for 3 days. It got ugly the way conversations get ugly when both people are saying true things that don't add up to the same conclusion. And then I said something I shouldn't have said, something about how he'd let the orchard die and the cattle go and the place turn into a deer camp. And he told me to get off the property. I did. I drove to Fort Worth and I didn't go back. And I told myself for 14 years that it was his decision to make and his problem to deal with. That was the worst decision I ever made. Not because of the fight, fights happen, but because the moment I walked away, my father was alone with that land and no one watching over what was about to happen to it. By 2010, he was 61 years old, semi-retired, and spending more time at the ranch than he had in years. I think he was lonely after my mother passed. I think the property filled something for him that he hadn't expected it to fill, and that's when Claudette Pryor found him. Claudette was 52 years old in 2010, Dallas-based. She ran a company called Pryor Heritage Land LLC, one of several entities she'd incorporated over the previous decade. On paper, she was a land developer specializing in what she called heritage property partnerships, which sounded legitimate enough that my father, a retired accountant who should have known better, didn't immediately flag it as the setup it was. She approached him at a Texas Landowners Association meeting in Fredericksburg, came prepared, knew the property history, knew the acreage, knew the tax records, told my father she represented a group of investors interested in developing a small, planned residential community on the eastern portion of the ranch. Not a sale, a ground lease. He'd retain full ownership of the land. She'd develop it, manage it, and pay him a fixed monthly ground lease rate, $2,000 a month, guaranteed, 5-year term. To a man sitting on 380 acres of largely unproductive hill country land paying property taxes every year and getting nothing back from it, that sounded reasonable. That sounded like finally making the land work the way it was supposed to. What my father did not read carefully, what Claudette had specifically structured so that it wouldn't be read carefully, was the section of the ground lease agreement granting her company full development and management rights over the eastern 200 acres during the lease term. That clause was the entire con. Because what Claudette did with that clause was not develop a small planned residential community. She platted 212 individual residential lots, filed permits under 3 separate shell companies, registered a homeowners association, Saddleback Ridge Estates HOA, as a private Texas corporation with herself as sole director, began marketing lots to buyers across Texas and beyond as deeded residential properties with full HOA amenities, and she did all of this before my father had cashed his 3rd monthly check. Here's what made the fraud so devastatingly effective. Claudette didn't just sell lots, she sold the entire package. She set up a title company, Hill Country Title Partners, that existed solely to process her own closings. Buyers received title commitment letters, title insurance policies, warranty deeds, all of it on official-looking letterhead, all of it completely fabricated. Hill Country Title Partners was never licensed by the Texas Department of Insurance, not for a single day. The shell company architecture was deliberate and layered. Prior Heritage Land LLC held the so-called development rights from the ground lease. Saddleback Ridge Management Company collected the HOA fees and handled community operations. Hill Country Title Partners processed the closings and issued the fake insurance policies. 3 separate entities, each with its own letterhead, its own bank accounts, its own paper trail. If any one piece got pulled on by a suspicious buyer or a curious attorney, the other 2 looked legitimate enough to provide cover. It was designed by someone who understood exactly how real estate fraud investigations begin, and exactly how to make each individual thread look clean when examined on its own. Homebuyers came from Austin, Dallas, Houston, San Antonio. Some came from out of state, Colorado, Florida, Tennessee. They drove out to the Hill Country, saw the land, saw the views, met with Claudette's sales team in a temporary office she set up on site in a converted trailer. They signed documents. They wired money. They went home believing they had purchased a piece of Texas Hill Country real estate. What they had actually purchased was paper. Expensive, official-looking, completely worthless paper. By 2013, there were 64 homes either built or under construction on the eastern portion of the Ransom Ranch. By 2015, when Claudette's ground lease with my father expired and she simply stopped renewing it, stopped sending the $2,000 monthly checks entirely, there were over 120 homes on the property and a fully operational HOA collecting monthly dues from every single resident. My father never noticed the checks stopped. By 2016, his dementia had progressed to the point where Cutter Briggs was managing his basic affairs from the foreman's cottage. My father spent his last years believing the ranch was still under some kind of active lease arrangement. He never questioned it. He never checked. He died in February of 2021 believing, I think, that he had done right by the land. He hadn't. But that wasn't entirely his fault. Cutter Briggs knew something was deeply wrong long before my father died. He'd watched the construction crews arrive, watched the streets get paved and the streetlights go up and the guard booth get installed at the front gate. He'd tried twice to talk to my father about it and gotten nowhere. Garrett would nod and say it was all part of the arrangement and then change the subject. So Cutter did what old ranch hands do when they know something is wrong but can't stop it. He started keeping records. Photographs, dates, license plates on Claudette's vehicles when she came for site visits, printed copies of the HOA's public Facebook posts, copies of the property tax records, a handwritten log he kept in a composition notebook, dated entries going back to 2011, documenting every unusual thing he observed on that property. He kept that notebook in the kitchen drawer of the foreman's cottage. And the morning I drove around the perimeter of my family's ranch and found that cottage still standing at the northeast corner, still with the same rusted tin roof my grandfather had put on it in 1974, and knocked on that door, Cutter Briggs opened it like he'd been waiting for exactly this moment. He looked at me for a long second. Then he stepped back and let me in. "Took you long enough," he said. "Your daddy never sold this land. He got robbed of it slow. And I've got 11 years of proof sitting in that drawer." He put the notebook on the table in front of me. I sat down and I started reading. Cutter's notebook changed everything. Not because it told me things I hadn't suspected. By that point, I'd seen enough to know something was seriously wrong. It changed everything because it gave me dates, specifics, a paper trail built by a 71-year-old ranch hand who had nothing to gain from keeping records except the quiet satisfaction of knowing that the truth was somewhere, written down, waiting. I spent 3 days in that cottage going through everything: the notebook, the photographs, the property tax printouts, the HOA's own public social media posts, which Cutter had been printing and dating every few months like a man who understood that the internet had a way of making things disappear when they became inconvenient. By the end of day 3, I had a clear enough picture to know 2 things. First, the land was unquestionably still mine under Texas law. The deed was recorded. The ground lease had expired. No legal transfer had ever occurred. Second, I was going to need an attorney before I made another move. Because Claudette Pryor had 11 years and somewhere north of $18 million invested in making sure this situation never got untangled, and people with that kind of investment don't let go without a fight. But before I found an attorney, I made one mistake. I requested a meeting with the HOA board. I know. Looking back on it now, I understand exactly how naive that was. But I was still operating with some baseline assumption that if I showed up with the original deed and laid it on the table in front of the people running this community, there would be some moment of recognition, some acknowledgement that something had gone wrong, and that reasonable people could begin figuring out how to fix it. What I got instead was Tuck Harlan. Claudette didn't even show up. She sent her enforcer, broad-shouldered, late 40s, the kind of man who'd spent enough years being physically large in rooms that he'd confused it with actual authority. Tuck arrived in an HOA polo shirt with his arms already crossed before he sat down, like the posture was a professional habit. I laid the deed on the conference table. The original 1961 recorded deed, certified copy from the Kerr County Clerk's office, every boundary line matching the footprint of the land currently occupied by Saddleback Ridge Estates. Tuck looked at it the way someone looks at a menu in a restaurant they've already decided to leave. "Sir," he said, "this community has been legally established and operating for over a decade. Whatever you think you have there, it won't hold up against 11 years of documented residential development." I asked him where the current ground lease was, the one authorizing that development. He said that was a matter for legal counsel. I asked him who owned the land the clubhouse was sitting on. He said that was also a matter for legal counsel. I picked the deed up off the table, folded it back into my jacket pocket, and walked out. Because I understood in that moment that this conversation had never been a negotiation. It had been a delay tactic, and Claudette Pryor had already made her next move before I'd even walked in the door. 48 hours later, I was served with legal papers. Claudette had filed a quiet title action in Travis County District Court, a legal maneuver designed to have a court formally declare who holds valid title to a disputed property. On its face, it sounds like the right tool for a situation like this. In practice, the way Claudette filed it, it was a weapon. Her argument was that the original ground lease, the 5-year agreement my father had signed in 2010, had created a de facto permanent development easement through 11 years of continuous, uncontested use and improvement of the property. In other words, because she'd been building on the land for over a decade without anyone stopping her, she was claiming that the law should now recognize her right to continue. She also filed an emergency injunction requesting that I be legally barred from entering the HOA's common areas, the clubhouse, the pool, the community streets, on the grounds that my presence constituted harassment and trespass against an established residential community. The injunction was temporarily granted within 72 hours, which meant that I, Wyatt Ransom, was legally prohibited from walking the streets of a neighborhood built entirely on land that had my family's name on the deed. Here's something worth understanding because Claudette was counting on most people not knowing this. A quiet title action is a legitimate legal tool used to resolve genuine disputes over property ownership, but it requires an actual legal basis, an unresolved competing claim, an ambiguous chain of title, some legitimate gray area in the ownership history. What it cannot do, and what no court is actually obligated to grant, is retroactively legitimize a fraudulent development built after a ground lease expired. The deed superiority principle in Texas is about as close to absolute as property law gets. A recorded deed does not become invalid because someone built on the land without permission. It doesn't matter how many houses went up. It doesn't matter how many families moved in. It doesn't matter how many years passed. The deed sits in the county record like an anchor, immovable, indifferent to everything that happened above it. What the construction proved wasn't ownership. It proved trespass. Claudette knew this. Her attorneys knew this. The quiet title filing wasn't about winning in court. It was about buying time, draining my resources, and making the legal fight expensive enough that I'd eventually consider settling for something less than what was already legally mine. That's how sophisticated fraudsters operate when they feel cornered. They don't retreat, they litigate. While her attorneys were buying time in Travis County, Claudette was working the community. Within a week of filing the injunction, she circulated a formal letter to every homeowner in Saddleback Ridge Estates. I got a copy later through Discovery. It was 3 pages long, professionally formatted, HOA letterhead, and it was one of the most deliberately dishonest documents I have ever read, and I spent 14 years in the military reading government paperwork. She described me as a fraudulent claimant, attempting to destabilize an established residential community through the presentation of a forged historical document. She called me a transient with no verifiable connection to the property. She told residents that her legal team had already identified multiple irregularities in the deed I was presenting, and that the matter would be resolved quickly in favor of the community. She ended the letter by encouraging residents to report any contact from me to the HOA board immediately, and to avoid engaging with me directly. The HOA's private Facebook group, 240 members, erupted within hours of that letter going out. Someone posted a photograph of my truck parked outside Cutter's cottage. There were comments I won't repeat. Tuck Harlan posted that residents should document any time they saw me on or near the property. 2 days later, I walked out to my truck in the morning and found both rear tires slashed. 3 days after that, there was a dead animal on the cottage porch. Cutter didn't flinch. He'd seen worse. He cleaned up the porch without saying a word and went back inside and poured us both a cup of coffee. But I'd be lying if I said it didn't get to me. Not the tires, not even the dead animal. What got to me was sitting inside that cottage at night, surrounded by documents, and genuinely asking myself whether I had the right to blow up 200 families' lives over a deed. These were people who had bought homes in good faith, people who had mortgages and kids in the local schools and lives they'd built here. Darlene Moss, who I didn't know yet but would, had paid $212,000 for her house, had 2 kids, had built her entire financial footing on this property. Was the deed worth that? I sat with that question for 2 nights. On the first night, I almost called the probate attorney and told him to explore settlement options. On the second night, I found myself staring at the ceiling of Cutter's spare room at 2 in the morning, thinking about my grandfather walking into that county recorder's office alone, with a cashier's check he'd spent 12 years earning. Then I found my grandfather's original land survey, the hand-drawn one from 1961, pencil lines, property corners marked with his handwriting, rolled up in a cardboard tube in the back of Cutter's closet. Cutter said my grandfather had given it to him personally, told him to keep it safe. I unrolled it on the kitchen table and looked at it for a long time. He had drawn every boundary line himself, labeled every creek crossing, every ridge line, every corner marker. In the bottom right corner, in his handwriting, it said, "Ransom land, built to last." That was the end of my 2-night crisis of conscience. The next morning, I called Sloan Vickers. Sloan was an Austin-based real estate fraud attorney, recommended to me by the probate attorney who'd handled my father's estate. She'd worked 3 HOA land fraud cases in Texas in the previous 6 years. 2 of them had ended in criminal referrals. When I described the situation to her over the phone, she was quiet for a moment, and then she said, "Send me the deed, the ground lease, and whatever your ranch hand has been keeping in that notebook. All of it. Tonight." I sent everything that evening. She called me back the next morning at 7:30. "Wyatt," she said, "Claudette Pryor didn't just commit civil fraud here. She committed wire fraud, mail fraud. She operated an unlicensed title insurance company. And depending on how the interstate buyer records shake out, this may have federal implications." She filed an emergency motion to dissolve the injunction that same week. Here's another thing worth knowing, because this is the kind of detail Claudette was counting on homebuyers not understanding at closing. Under Texas Property Code Section 12.001, a deed that has been properly recorded with the county clerk provides constructive notice to the entire world. That means that from the moment my grandfather recorded that deed in 1961, every single person who subsequently dealt with that land, every developer, every buyer, every title company, was legally assumed to have known about it. You cannot claim you didn't know a deed existed if it was sitting in the public county records the entire time. This is not a technicality. This is the entire foundation of property law. The public record system exists precisely so that ownership cannot be disputed based on what someone claims they did or didn't know. Claudette's fake title company should have run a title search before every single closing. A legitimate title search, the kind any licensed title company in Texas runs as a matter of basic procedure, would have found the ransom deed in approximately 4 minutes. It would have shown up on the very first page of the search results. Claudette's company never ran those searches because Claudette already knew exactly what they would find. She wasn't negligent. She was deliberate. There is a significant legal difference between those two things, and that difference would eventually matter enormously in a federal courtroom. What Sloan found when she subpoenaed Claudette's financial records during the discovery phase nearly took both of us off our feet. The HOA fees, averaging $400 per household per month across 212 homes, had never once been deposited into an HOA reserve account or an escrow account, or any account that had anything to do with community management. Every dollar had been deposited directly into accounts controlled personally by Claudette Pryor. Across 11 years, that was approximately $11 million in HOA fees alone. The lot sale proceeds, documented across 187 completed closings through Hill Country Title Partners, added another $14.7 million. Total documented fraud, just under $18.9 million. And Hill Country Title Partners, the company that had issued title insurance policies to every single buyer in Saddleback Ridge Estates, the policies those buyers were counting on to protect their investments, had never held a license from the Texas Department of Insurance, not for a single day of its existence. Every policy it had ever issued was legally worthless. That last part was what brought Darlene Moss to my door. She'd heard through a neighbor that I was the actual landowner. She drove to Cutter's cottage on a Tuesday evening, knocked on the door, and stood there in the doorway with her hands clasped in front of her and her jaw set in that particular way people hold themselves together when they are very close to falling apart. "I paid $212,000 for my house," she said. "I have 2 kids. My title insurance is fake. If I lose this land, I have nothing. I have absolutely nothing." I looked at her standing there and I thought about my grandfather's handwriting on the bottom of that survey. Built to last. "You're not going to lose your home," I told her. "I'm going to make sure of that." I meant it when I said it. I just didn't know yet exactly how hard keeping that promise was going to be. Because while Sloan was building our case in Austin, Claudette was doing what people with money and desperation do when they feel the walls starting to close. She called in a political favor. Sheriff Bud Pickett had been Kerr County Sheriff for 16 years. He and Claudette had a relationship that went back to a county commissioner's fundraiser in 2012, the kind of relationship that doesn't get written down anywhere, but that both parties understand perfectly well. When Claudette called him and described the situation as a civil property dispute being weaponized by a disgruntled heir, Pickett classified it exactly that way in the department's system. No criminal investigation opened, no fraud referral made. Civil matter, not law enforcement's jurisdiction. Tuck Harlan, emboldened by Pickett's classification, began following my truck. Not subtle about it either. Same black Ford 152 car lengths back every time I drove into Kerrville. Claudette hired a private investigator to dig through my military service record, looking for anything that could be used to discredit me publicly. They found a decade-old administrative reprimand from 2009, minor, procedural, the kind of thing that exists in thousands of service records, and tried to leak it to a local newspaper reporter as evidence that I was unstable and had a history of confrontational behavior. The reporter called Sloan for comment before running anything. Sloan told her to look into Hill Country Title Partners' licensing status with the Texas Department of Insurance instead. The reporter made one phone call to the TDI. She never wrote the story about me. Sloan called me on a Thursday morning in early October. Not her usual 7:30 check-in call. This was 11 at night Texas time, and when I picked up, she didn't bother with a greeting. "Wyatt, I need you to listen carefully. I've been going through the buyer records from Hill Country Title Partners. 41 of the 187 closings involve buyers who wired purchase funds from out-of-state bank accounts. Colorado, Florida, Tennessee, Georgia. The moment money crosses state lines through electronic transfer in furtherance of a fraud scheme, that's not a Texas civil matter anymore. That's federal wire fraud. I'm contacting the FBI's Financial Crimes Division in San Antonio tomorrow morning." I sat with that for a moment. "How serious is this?" I asked. Claudette Pryor built an $18 million fraud operation and ran it for 11 years, Sloan said. On the federal level, this is very serious. She filed the referral the next morning. The FBI opened a preliminary investigation within the week. Quietly, no announcements, no press. 2 field agents made contact with Sloan directly and told us one thing clearly: say nothing to anyone. Let it develop. So I went back to Cutter's cottage and I waited. The injunction hearing came first. Travis County District Court. Sloan had filed an emergency motion to dissolve Claudette's temporary injunction, the one that had been keeping me legally barred from my own land for 6 weeks. Claudette's Austin litigation firm showed up with a 3-attorney team and a 4-inch binder of exhibits. They had photographs of the community, testimonials from residents, a timeline of development activity going back to 2010. What they did not have was a valid legal instrument connecting Claudette's development rights to the present day. Sloan stood up and made a single, clean argument. The ground lease signed in 2010 expired in 2015. It was never renewed. No extension was filed. No new agreement was executed. Under Texas law, when a ground lease expires without renewal, all rights granted under that lease terminate automatically. There was no legal document in existence, not one, that gave Claudette Pryor or any of her entities the right to occupy, develop, or manage 1 square inch of the Ransom property after the summer of 2015. The judge looked at Claudette's legal team over his glasses. "Counselors, is there a current executed ground lease or any successor agreement in evidence?" Claudette's lead attorney shuffled papers for a moment longer than was comfortable. "Your Honor, we would argue that the continuous development activity constitutes an implied—" "I didn't ask about implied agreements," the judge said. "I asked about executed documents. Is there one or isn't there?" Silence. "The injunction is dissolved. The plaintiff has full legal right of access to the property described in the recorded deed. We're adjourned." I walked out of that courthouse and stood on the steps in the October sun for a moment. 6 weeks of being legally locked off my own land. 6 weeks of slashed tires and dead animals on the porch and Tuck Harlan's truck in my rearview mirror. Sloan came out behind me and put her hand briefly on my arm. "Now we go in," she said. I drove to Saddleback Ridge Estates that afternoon, pulled up to the gate. The same guard in the same polo shirt stepped out of the same booth. He recognized me immediately. His whole posture changed. I handed him a certified copy of the court order through the window. "Call whoever you need to call," I said, "but this gate opens." He called Tuck Harlan. Tuck called Claudette. I sat in my truck for 4 minutes while that chain of panic worked itself out. Then the gate opened. I drove through slowly, down the main street of Saddleback Ridge Estates, past the manicured lawns and the brick mailboxes and the community pool still open in the October warmth. Residents standing in driveways stopped and watched my truck pass. Some of them knew exactly who I was. Some of them were figuring it out in real time. I drove to the center of the community, to the clubhouse parking lot, and I parked. Then I called Cutter. "It's open," I said. "About time," he said. 3 days later, Claudette called an emergency HOA meeting. 212 households received notice. The clubhouse, which seated about 140 comfortably, had people standing along every wall and spilling out the side doors into the parking lot. Claudette had framed the meeting as an important legal update regarding recent developments. She planned to stand up in front of her community, characterize the dissolved injunction as a temporary procedural setback, reassure everyone that her legal team had the situation under control, and maintain the grip she'd held on this community for 11 years through a combination of authority, polish, and the particular confidence of someone who has never been seriously challenged. What she didn't know was that Sloan and I were coming. We arrived 10 minutes after the meeting started. I could hear Claudette's voice through the closed doors, measured, calm, that corporate smoothness she deployed like a tool. Tuck Harlan was stationed at the entrance. He saw me and physically stepped into the doorway, shoulders squared, arms at his sides. I held up the court order. "I have a legal right to be in this building," I said quietly. "It's on my land. Step aside, Tuck." He looked at the order, looked at me, looked at Sloan behind me, and then he moved. We walked in. The room went quiet the moment I stepped through the door. Claudette was at the front behind a podium. She saw me and something moved across her face. Not fear exactly. more like the expression of a person who has just realized that the timeline they carefully constructed has been punctured somewhere they didn't expect. She recovered fast. "This is a private HOA meeting. You're not a resident." "No," I said. "I'm the landowner. There's a difference." Sloan stepped forward and nodded to the process server who had come in behind us. He crossed the room in 8 steps and handed Claudette the civil suit filing. In front of every person in that building. She took the papers without looking at them. I asked for the floor. There was a long moment where the room collectively decided what kind of meeting this was going to be. Then someone near the back said, "Let him talk." And then a few more voices. And then it was settled. I walked to the front of the room. I didn't have notes. I didn't need them. I'd been living inside this information for months. I told them everything. I started with my grandfather quarrying limestone on the Western Ridge in 1961. I told them about the ground lease my father signed in 2010 and the clause that Claudette had buried in the fine print. I told them the lease expired in 2015 and was never renewed. I told them about Hill Country Title Partners, that it had never held a license from the Texas Department of Insurance, that every title insurance policy every one of them had received at closing was legally worthless. I told them about the HOA fees, $400 a month, 212 households, 11 years, deposited not into a community reserve account, but directly into Claudette's personal accounts. Sloan had brought a laptop and a portable projector. She pulled up Claudette's bank deposit records on the wall screen, the ones obtained through the discovery subpoena. Column after column of HOA fee deposits, 11 years of them, every dollar accounted for, every dollar going to one place. The room didn't erupt. It went the other direction. That particular heavy silence that falls over people when they are absorbing something too large and too ugly to react to immediately. Darlene Moss was sitting in the 3rd row. I watched her look at the screen, watched her jaw tighten. She'd known pieces of this. Hearing it laid out in full, in public, in front of 200 of her neighbors, was different. She stood up. "She told us our title was clean," Darlene said. Her voice was steady, but just barely. "She looked every single one of us in the eye at closing and told us our title was clean." The room started moving then, people turning to each other, voices rising. Someone near the back asked about their mortgage. What happened to their mortgage if the title was invalid? Someone else asked about their homeowner's insurance. A man near the sidewall said he'd put $400,000 into his property. Another woman near the front, I didn't know her name then but learned it later, stood up and said she had driven from Houston to that converted trailer on a Saturday morning 6 years ago and handed over a wire transfer for $260,000 because Claudette's sales team had told her the Hill Country title process was faster than standard because the development had its own in-house title company. She said it like someone finally understanding, in real time, in public, that the thing they'd been told was a feature had actually been the trap. The weight of it settled over that room like weather coming in. Claudette had been standing at the side of the podium through all of this, maintaining composure, the way a person maintains composure when they are calculating exit options. Her eyes had moved twice toward the side door. Her hand had adjusted her jacket lapel, once, then again. The small, involuntary movements of someone whose external stillness is costing them something. She moved toward the door. I didn't stop her. I didn't need to. I just said, loud enough for the room to hear, "You're already in court, Claudette. You've been there since 2015. The only difference is now everyone in this room knows it." She walked out without responding. Tuck Harlan had already been gone for 10 minutes. What happened over the following 3 weeks moved faster than I expected, partly because of what Sloan had set in motion, and partly because Claudette, for the first time in 11 years, made a desperate move. She contacted Sheriff Bud Pickett again. This time, not to classify things as a civil dispute, but to ask him to intervene on her behalf, to find some angle, some procedural mechanism, some way to slow down what was clearly now an unstoppable legal process. What Claudette didn't know was that the FBI field agents working the preliminary investigation had already made contact with Pickett directly. Federal jurisdiction had effectively been established the moment out-of-state wire transfers entered the picture. Pickett had no more room to maneuver. He issued a warrant for Claudette's full financial records, not because he wanted to, but because he had no legal choice left. Claudette's Austin litigation firm withdrew from representation the same week. A conflict of interest had been identified. One of the firm's partners had done incorporation work for one of Claudette's shell companies years earlier. They couldn't represent her in a fraud case involving entities they'd helped create. She scrambled for new counsel. 3 firms declined. A 4th took an initial retainer and then went quiet. And then Tuck Harlan flipped. He called Sloan's office on a Wednesday morning and offered full cooperation with federal investigators in exchange for reduced exposure. Tuck had been Claudette's enforcer, but he was not her architect. He knew the operational details, the site visits, the intimidation tactics, the coordination between the shell companies, but the financial structure had been entirely Claudette's design. The federal prosecutors were interested in Claudette. Tuck was a path to her. They took the deal. Now here is something the federal prosecutors explained to me later that I think every property owner in this country needs to understand. Federal wire fraud under 18 U.S.C. Section 1343 is triggered the moment electronic communications or wire transfers are used to execute a fraudulent scheme across state lines. It does not require physical movement across a border. It does not require a federal agency to be directly involved. The moment Claudette's HOA payment portal processed a monthly fee from a homeowner who had relocated to Tennessee, the moment her fake title company received a wire from a buyer's bank in Colorado, federal jurisdiction attached. Automatically. Permanently. Every single one of those transactions became a separate count. She had given federal prosecutors 41 counts of wire fraud before she had ever sent a single email to an out-of-state attorney. That is how an 11-year local land fraud scheme became a federal case that no amount of political connection or high-priced litigation could contain. The joint FBI and Texas Attorney General press conference was held on a November morning at the federal courthouse in San Antonio. I watched it on a laptop in Cutter's kitchen. Claudette Pryor had been indicted on 18 counts of federal wire fraud, 9 counts of mail fraud, unlicensed operation of a title insurance company, and fraudulent conveyance of real property. Total documented fraud, $18.9 million across 11 years of operation. The arrest had been made at her Dallas home at 6:15 that morning. The footage was on the local news by noon. Claudette in the parking lot of her building, hands behind her back. The particular expression of a person who spent 11 years believing they were too smart and too careful to ever stand exactly where they were standing. Cutter watched the footage once. Then he got up, refilled his coffee, and looked out the kitchen window at the western ridge, the one my grandfather had quarried limestone from 60 years ago. "Deeds don't lie," he said. He wasn't talking to me. He was just saying it, the way you say something that has finally, after a very long time, been proven true. The federal trial lasted 11 days. Claudette's 4th attorney, the one who'd gone quiet after taking her retainer, showed up and did what underprepared defense attorneys do when the evidence against their client is overwhelming. He objected frequently, delayed where he could, and made arguments that the judge disposed of with the particular efficiency of someone who has seen the same tactics too many times to be impressed by them. Tuck Harlan testified for 2.5 days. He was precise, detailed, and clearly had made his peace with the fact that the only path forward for him ran directly through the truth. He walked the jury through the shell company structure, the fake title operation, the HOA fee routing, the intimidation campaign. He described Claudette's instructions at each stage with the flat specificity of a man recounting facts, rather than constructing a narrative. The jury deliberated for 4 hours, guilty on all 27 counts. Sentencing came 6 weeks later. Claudette Pryor stood before the federal judge in a charcoal gray suit, still composed, still holding that corporate posture she'd carried into every room for 30 years. Her attorney made the expected arguments about first-time offense status, about her age, about the complexity of the transactions suggesting ambiguity rather than criminal intent. The judge listened to all of it. Then he looked at Claudette directly and said what needed to be said. "Miss Pryor, you did not make an error in judgment. You did not misread a contract or misunderstand a legal boundary. You constructed an elaborate, multi-layered fraud operation and ran it for 11 years with full knowledge of what you were doing at every stage. You collected nearly $19 million from families who trusted you with their life savings. You issued fake title insurance policies that left those families completely unprotected. And when you were challenged, you used legal mechanisms, political connections, and personal intimidation to try to bury the truth rather than correct it." He paused. 14 years. Federal. Full restitution of $18.9 million. Your real estate license is permanently revoked in the state of Texas. We're adjourned. Claudette didn't react visibly. She stood still while her attorney gathered his papers. Then the marshal stepped forward, and that was the end of Claudette Pryor's 11-year run. Tuck Harlan received 3 years probation and a permanent ban from serving on any HOA board in the state of Texas. It was a light outcome for what he'd participated in, but he'd earned it by telling the truth when it mattered. Sheriff Bud Pickett did not face criminal charges. The federal investigators determined his involvement hadn't crossed into active obstruction, but he announced 6 months later that he would not be seeking re-election. 16 years as Kerr County Sheriff, and he left without a farewell ceremony. Some exits are quiet because they have to be. The shell companies were dissolved by court order within 30 days of sentencing. Hill Country Title Partners, Pryor Heritage Land LLC, Saddleback Ridge Management Company, all of them liquidated. The proceeds, combined with asset seizures from Claudette's personal accounts, formed the basis of the restitution pool distributed to defrauded homeowners. Every buyer who had purchased a lot through Hill Country Title Partners received a restitution payment covering their fake title insurance fees, their fraudulent closing costs, and a portion of the HOA fees paid during the period of demonstrated fraud. It wasn't a full recovery for everyone. Restitution rarely is. But it was real money, court-ordered and documented, going back to the people it had been taken from. The Texas Department of Insurance also opened a separate victim compensation process for homeowners whose title insurance claims had been left invalid by Hill Country Title Partners' unlicensed operation. That process took another 14 months to fully resolve, but it resolved. Sloan worked with the Texas Attorney General's office to create a structured framework for the homeowners still living on ransom land. Every household was offered a legitimate, long-term ground lease, 50 years, renewable, at a fair market rate established by an independent appraiser. The terms were real, the documents were real, the title chain was real. For the first time since they'd moved in, residents of what had been Saddleback Ridge Estates had paperwork that would actually hold up in a court of law. The community voted to rename the neighborhood. 201 households participated in the vote. The name they chose, by a margin that wasn't particularly close, was Ransom Ridge. I didn't suggest it. I wouldn't have. But I won't pretend it didn't mean something when Sloan called me with the result. A legitimate HOA was formed under Texas nonprofit law, properly incorporated, properly governed, with an elected board, published financials, and an actual reserve account that actual HOA fees actually went into. The first board meeting was held in the same clubhouse where I'd stood in front of 200 people and laid out 11 years of fraud on a projected screen. It looked different with the lights up and the chairs arranged properly and people sitting in them who were there because they wanted to be, not because they were afraid of what would happen if they weren't. Darlene Moss signed her ground lease on a Tuesday morning in Sloan's Austin office. She brought her 2 kids, a boy of about 9 and a girl maybe 6. They sat in the chairs along the wall and watched their mother sign documents with the focused attention of children who understand that something important is happening without fully knowing what. When it was done, Darlene looked up from the paperwork and across the table at me. "You didn't have to do any of this," she said. "The way you structured it, you could have taken the land back clean and left us all to sort it out ourselves." "My grandfather built this land for people to live on," I said. "Just not like that." She nodded. That was enough. On the drive back to Kerrville, I pulled over on Highway 16 where the road crests a ridge, and you can see the hill country spread out to the west, cedar and limestone, and the particular pale green of Texas scrub in the late afternoon light. I sat there for a while with the window down. Cutter Briggs got his cottage formalized in writing. Lifetime residency rights, maintenance covered by the new HOA, utilities included. He read the document twice, signed it without ceremony, and folded it into the kitchen drawer where the composition notebook used to be. That evening we sat on the cottage porch, the same porch where he'd cleaned up the dead animal without comment. The same porch where I'd sat with a cup of coffee questioning whether any of this was worth fighting for. The sun was going down behind the western ridge, and the cedar was throwing long shadows across the limestone, and the air had that particular quality it gets in the hill country in November, cool and dry and completely still. Cutter reached into his shirt pocket and laid a photograph on the arm of my chair, black and white, slightly faded, A man standing in front of a ranch gate, one hand resting on the post, squinting slightly into what must have been a bright afternoon sun. On the back, in pencil, Holt Ransom, Ransom Ranch, 1962. My grandfather, 31 years old, standing at the entrance to the land he had built with $11,000 and 12 years of saved wages and 2 years of his own physical labor, looking at the camera like a man who has just finished something and knows it was worth doing. I carried that photograph inside and pinned it above the fireplace in the main ranch house, the limestone one, with the cedar beam roof and the stone floors. Restored now, not renovated. Every original element intact, the way my grandfather left it. The cattle operation started the following spring, modest, 40 head on the western 80 acres, the same ground my grandfather ran cattle on 60 years ago. The peach orchard on the South 40 got replanted, 23 new trees, same variety Holt had planted originally. They won't produce for another 3 years. That's fine. Some things are worth planting for later. The flagpole Holt Ransom sank into the ground in 1961 is still standing at the front of the ranch house. The concrete around the base has cracked and been repaired twice. The pole itself is original. Every morning I run the flag up before I start the day. It's a simple thing, but simple things have a way of meaning everything when you understand what it costs to keep them. Claudette Pryor spent 11 years building something on land that wasn't hers. She built it carefully, and she built it convincingly, and for a long time it worked exactly the way she designed it to work. But she made one foundational mistake, the same mistake everyone makes who tries to build something permanent on a lie. She forgot about the deed. Deeds don't expire. They don't care how many years have passed or how much money has changed hands or how many houses have been built on top of them. They sit in the county recorder's office in a filing system that has been running continuously since 1961. And they wait. Patient as limestone. Permanent as the land itself. My grandfather understood that when he walked into that recorder's office 60 years ago with a cashier's check and a hand-drawn survey. I understand it now. If you've ever dealt with an HOA that operated more like a crime ring than a community, drop your story in the comments. Every single one gets read. And if this story hits something real for you, you know what to do. This is Wyatt Ransom, and this land is exactly where it was always supposed to be.